start by acknowledging the Yagara people. Really proud to be working on their native title claim at the moment. So recognising their connection to country from the mouth of the Brisbane River right up to the foothills of the Toowoomba Range. I should also, obviously, I want to acknowledge Mullenjaiwakka and his daughter Philippa for Philippa's endorsement to be able to give this speech tonight, and I want to say a few words about Mullenjaiwakka shortly. Also, whilst I'm doing acknowledgements, I rarely get the opportunity to do this, and I want to acknowledge both Kevin Smith and Tony McAvoy, and I also want to acknowledge Kevin Williams. I've been very fortunate. 18 years ago, I started work at Queensland South. I got to meet Tony, and I got to work under Kevin, and I have considered them friends and mentors and a big support for a very long time. And tonight's theme, I want to talk about making a contribution to the law and supporting the next generation, and there's no better example than Kevin and what he's done. Firstly, down at New South Wales with the pre-law program at, I think, UNSW, and now working hard up at Sunshine Coast University. So any blackfellas looking to get to uni, if you go up to Sunshine Coast University, you'll be well supported by Kevin. And I just want to, as I say a few comments about Mullenjaiwakka. And I had a few opportunities to meet him, obviously, in his time in Brisbane, when the Bar Association would hold events, or when we're attending dinners for his Lloydies program. And one of the things that has really stuck with me about him is his commitment to supporting the next generation. And there's no better example than the Lloydies program that he sponsored and supported a lot of Indigenous rugby union players coming through. But also the time he had for all of us, whether you're sitting at an event like this or whether you're sitting at a cafe somewhere, he was always willing to speak and share his knowledge. And so in that vein, I wanted to speak about similar things today. I'm not going to give you a lecture on Section 9 of the Racial Discrimination Act or the Native Title Act, or I'm going to talk to you about those things that Cassie sort of mentioned that are important to me. And I just wanted to say too, and obviously acknowledging the importance of the oration and the quality of speakers, there's been an esteemed panel of speakers before me, including Tony and Louise, and they did have an esteemed speaker planned tonight, but Justice Crowley was away. And so you'll get back to that quality speaker next year, but if you just indulge me for the next 35, 40 minutes, you'll learn a few things. I learned really early in my career the value of my contribution, but also the importance of my perspective. And I learned that my perspective right from the start was very different to others. And two examples I wanted to speak to you about that really come to mind. The first was at a dinner, a bit like this. It was a Griffith University dinner. I think I was still a student. I hadn't been practising as a lawyer yet. And we were sitting at a table, and I was sitting next to someone fairly senior at the Law Society, as I am here with the President tonight, but sitting next to someone fairly senior at the Law Society. And I don't remember anything about the discussion, but for the fact, I said to them, there's a need for Indigenous judges in Queensland. And so I was probably wide-eyed and early in my career, a bit like many of you in the room. And the response I got back was like, well, that's not going to happen anytime soon. And so I thought, well, I'm going to try and do something about that. And so then I said to myself, I'm going to meet with every Attorney General. And so as a young law student, I think I was towards the end of my degree, I started meeting with all the Attorney General. I met with Paul Lucas, I met with Cameron Dick, I met with Jared Blay, I met with Yvette Darth, and I met with Shannon Fentiman. I haven't had my meeting this time with this AG, given we got off to a rocky start with me and the government. I don't think I'll be scheduling that meeting. But what I did realise in that is I do have a different perspective, and that perspective is valued and listened to. And that was a really important lesson for me in those early days of my career. And the other example I want to talk to before I then talk about other things was my time as an associate, and I was very fortunate to be an associate to the late Justice Jutney, Supreme Court Judge. And we're in a trial, and he did a lot of commercial matters, but we just happened to be doing this murder trial at the start of the year. And the murder trial happened somewhere in southeast Queensland, and it happened in a park. It happened in a block of units across the road from a park. And the counsel in their cross-examination or their evidence in chief would be saying, well, you know, this park, there were lots of bad people, there were alcoholics, there were drug addicts, and, you know, there are Aboriginals in there. I was like... And so I walk, anyway, so we get out of the end of the day or whatever, I walk out of court, and I had this judge was a great judge, and I said, see, Judge, you just have to say the word Indigenous, and there's this negative connotation to it. And the judge was like, yeah, I took it on board. And anyway, so we go back to the rest of the hearing. It might have been a 4-day trial or something. And the counsel never said it again. They never said there's Aboriginal people in the park. And I think it sort of shows the value of speaking up too, right? It's good to have perspective, but you also need to action those things. Now, as I said, I was really fortunate in my legal career to know right from this early on that I wanted to be a barrister. I had worked as a clerk at Legal Aid, at a clerkship over the university holidays, and right from the start I saw what barristers did in court, and I was like, wow, that's me. Like, I want to be the person on my feet, I want to be the person who's got the responsibility, all those things. And then in my final year of university, as I said, I got to work with Queensland South Native Title Services, and probably up until the Truth Telling Inquiry, that was really the highlight of my working career. To be working in an Indigenous organisation, led by Indigenous people, working with other Indigenous mob, you know, out on country doing native title stuff. It was really the pinnacle for me, and all the relationships I've had. But I was really focused on going to the bar from that work experience, and a bit like Keely Hughes is at my table. Keely's focused on going to the criminal bar, and for me, I wanted to finish uni on Friday, and I wanted to start at the bar on Monday. And, you know, that's not practical, it can't happen, but that's really that was the goal for 10 years. All I want to do is be a barrister. And I was very fortunate to have good mentors and people like Dan O'Gorman, who's a senior counsel here in Brisbane, and Dan said, look, just cool your jets a bit, Josh. Says, I love the determination, but, you know, you should practice or work with a judge for a year as an associate, and Dan helped me get that role, and then they said spend a year in a law firm, and I did that on the Gold Coast. But after all those things, I was ready to go to the bar. And it was funny because, as I say, it's a goal for 10 years. It's all I wanted to do, and then I finally get there, I enrol on the bar course, and they give me a call because I got admitted in December and I was starting the bar course in January, and they said, well, we're oversubscribed. It's only people who are really going to go to the bar, so we can't get you into this block. And I again called in a few favours, and I said, Dan, you know, I'm ready to go. So anyway, magically I get into the bar course. So networks are everything in law. If it's not a... But and I get to the bar, and it's one of those things that people think of the bar that, you know, you've got to study for 100 years and be some oracle in law, and you've got to have heaps of money in the bank, and that I was neither of those. I think when I started at the bar, I had to borrow some money to pay for the bar course. It was about $3,000, so I had to borrow that money, and then the Mullenjaiwakka Trust that the Bar Association has reimbursed my bar course fees, and then I used that money to buy my robes. And so I went to the bar with about $250 in the bank. And I guess for me, growing up in Mount Isa and then Central Queensland, and, you know, a single mother, I didn't ever see money as a marker or as a requirement to be successful. So I didn't think I needed tens of thousands of dollars. I knew I had enough. I knew my determination and my desire, I had enough to do. And there's always this discussion, you know, for us as Indigenous lawyers, you know, what work should we be doing? Should we do the Indigenous stuff? Should we go and do the other stuff? And I remember having this conversation with my wife when I was just about to start in the bar course, and I said to her, you know, if I have the greatest career but don't make an impact for the mob, what's the real value of it? It's not of any value. And so I knew really early on I wanted to be working in an area which had an impact on Indigenous rights. Unfortunately, the experience at Queensland South, and I started in native title, but that desire to do work in that space has obviously led on to many other things. And I started at the bar, and I remember I was thinking about what I was going to say, and I remember I wouldn't have been able to start at the bar without the goodwill of people like Andrew Bowe and Peter Callaghan, I think Peter's still on the Supreme Court. But as I say, I had no money, but they gave me a room in their chambers, and I could have access to all the resources and everything. And so they gave me this pupil room for 6 months. And I really hit the ground running. I hit the ground running because of people like Graham Harley, who got me to do some work in native title with them. And even people I'd worked with, they sort of started to flick me work. But I remember the first matter I did, and it might have been, it was some magistrate's court mention or a hearing or something somewhere. It might have been a sentence. And I remember at the end I got paid like $250, and I was like, wow. I used to work all weekend for this when I was at university, and I've read a brief and I've rocked up to court, and I was probably wearing my robes too, and I thought, wow, this is it. Like I've made it, And I did. I made it because that was a goal for like 10 years to really get there and to start, and I started. And those sort of early stages of my career, you take on whatever work, but there's a few really defining moments in my career. And it really started the work I did on the Palm Island case, the Wotton v State of Queensland. And that was an interesting case because we'd just had my oldest, she was a baby, and my wife was out home on maternity leave, and I was spending as much time as I could out home, so I was only trying to go into chambers 1 or 2 days a week. And I got this brief, this Palm Island brief, and I was like, and they wanted this advice, they wanted advice on evidence. And I think it was around July, it must have been 2024. And I was like, this advice is due, I better read this material and get into it. And so I start reading this material and I give this advice. And it was probably, I haven't looked back at the advice, it was probably an awful advice, but what I did do well is I did say to them, you can't see what happened in relation to the death of Mullenjaiwakka and the response as an isolated incident. You have to see it in the context of the history of Palm Island, because everything that happens on Palm Island today is it's an outcome of the history, the horrible history on Palm Island. And that case was an absolute, and I want to give you some behind the scenes tonight. So that case was an absolute basket case. It had been run on a sort of speculative basis out of Sydney, and a few young lawyers, and there was a couple of silks who were like, oh, come in, we'll do a couple of days of the hearing. It was going to be a 4-week hearing, and some juniors dropping in and out. And I was sitting around the water cooler in chambers, and I was talking to one of the barristers there, and he said, have you thought about Chris Ronalds, for this? Because I said, we need a good silk. And I remember I got on the phone to the solicitors in Sydney, and I said, this is the line, you don't win cases like these without heavyweights. And Chris is a heavyweight, if you've ever worked with her in that space. And so Chris comes in a few weeks before the trial, right? This is sort of the brilliance of having all these expertise. She comes in a few weeks before the trial. And I remember when we first landed in Palm Island, and I'd gone up there a couple of times to prepare evidence and all these things, and we first get to Palm Island a day or two before the trial. And I see Chris walking with Lex Wotton and just preparing his evidence, and I was really in awe of the way she was going about it. She just came into this case at the last minute. She'd been in a holiday in Laos. I'd sort of begged her to come on. I'd try and, persuaded the solicitors to go and see her, and it all come together. And one of the things about law and running these big cases, and I guess it's running every case, is evidence and strategy wins cases. And I think often when you're starting out, on these big cases, you've got to understand the importance of having the right strategy. And for me, that's about convincing the person who's going to make the decision. And that might be a judge. If you're negotiating class actions, it might be the Premier or the Minister or the Treasurer. Whatever it is. I spend a lot of time on the cases I work on, the big cases, thinking about how it is I'm going to convince the decision maker. And that could be me thinking about these things for years, because I do work on some of these big cases for years. And one of the things that Chris said to me, which was really was pertinent in terms of the context, is she said that there's never been an inquiry into what happened on Palm Island. And if it had happened anywhere else in Australia, or this type of issue, there would have been a big inquiry. But because it was Palm Island and people wanted to sweep it under the carpet, we don't want to investigate it. So Chris was like, we're going to conduct this like an inquiry. We're going to be methodical in our approach, and we're going to step it through second by second as to what happened. Now, Palm Island's a remarkable case, and it's remarkable for many reasons. But for me, the most significant reason is an entire Aboriginal community sued a state government for racial discrimination and won. I mean, in the context of history, that's really significant. And in context of Palm Island's history, Palm Island was established as Punishment Island. So, if you know the history of Queensland, about 200,000 First Nations people at the time the British arrived. That population was reduced down to 25,000 between 1830 and 1897. So 25,000 left, almost 90% of the population gone. 22,000 of those moved to missions and settlements and reserves across Queensland, and we see that total control exercised over, lots of our elders and lots of our people. And Palm Island was the worst place of all. It was established with the intention of it to be a place to punish everyone who was sent there from other missions. And there were a few moments on Palm Island that really stick with me. I'd spent a lot of time up there, and I will forever have a close bond with Lex and many on the island. But there was one of the young girls had attempted to commit suicide just before the hearing. She didn't, but fortunately. But I remember I was really upset, and I called the solicitor in Sydney and I said, I really want to win this case for the people of Palm Island because they deserve a win. And then I got picked up the next day by one of the ladies, and I said, it's upsetting what happened. And then she drove me around to all the places where sorry business had occurred on their island the next day. And it just really reinforced the reality of, the experience of people growing up in those missions and still the legacy of those missions that haunt our people today. And if you haven't read the facts on Palm Island, you should. Mullenjaiwakka walking down the street. There's an arrest occurring at a house on Palm Island. Mullenjaiwakka walks past. He finds himself in the back of the paddy wagon. They're driven about 5 minutes down the road because everywhere's 5 minutes on Palm. They get out of Mullenjaiwakka, gets taken out of the back of the paddy wagon. There's an altercation between him and Hurley, SS Hurley, Senior Sergeant Hurley. And then I see the video of him in his cell, and I could see the spirit leave his body, is what I saw when I watched that video of him dying on the cell floor. Ultimately, a week later, I think there's the autopsy report. He has his portal vein cleaved in two. I think he's got a broken rib, a cut above his eye, and he has another significant injury. And I think ultimately the injuries were described as akin to a car accident. And when that autopsy report's read out to the mob in Palm in the mall area, there's civil unrest. They go and burn down the police station and then the adjoining courthouse. Palm Island's a place where they only ever had 7 police, 4 rostered on at one time. They'd never wear guns. And they ended up sending over 120 police to Palm Island in the hours afterwards. And they were led by the CERT and PSRT, so the CERT and the riot squad, or SWAT, what you would think of SWAT and the riot squad. And they hold the whole island hostage, basically, for the next week. And they conduct raids on people's homes, the little houses in the communities, 10 people in the house, women, children, babies. The CERT teams had run in with their assault rifles. And they did 18 raids, and then they assaulted a lot of kids down at a place called Wallaby Point as well. And it turned into a training exercise for the police, because they'd never worked together as a team, those two teams. And it was so stupid. They would go to a house and they'd say, "Oh, is Josh Creamer here?" Josh Creamer, "Oh no, he's down the road." And then the next house, they'd raid 7 homes looking for Josh Creamer. Turns out Josh Creamer hears they want him and goes and hands himself in at the police station. So, all this sort of unnecessary trauma is inflicted on people. And that hearing in itself, I think we had probably 25 odd witnesses, and not every single one of those witnesses broke down in the witness box 3 or 4 times. And, you talk about the importance of strategy, and I know that Tony was talking to Chris about this, that if we're going to have the hearing on the island, you've got to take the judge out to look at these locations, right? She's got to understand what it's like to live in one of these homes and to have these police running in. So, that was something we did. And I obviously would never have talked to the judge about it, but everybody who was involved in that case could certainly feel the emotions of it. Now, what I did learn from Palm Island and what I took away from it, and it's something I've used in all the other cases that I've been involved with, was ultimately, as brutal as those facts are, and they're probably as extreme, that's probably as extreme as it could get in Australia. You wouldn't ever be able to do that again in Australia, what happened on Palm Island, as a police response to a community. But I took away from it that at its barest bones, it's a case about service provision. It's a case about government providing services to Aboriginal and Torres Strait Islander people. And while that sounds a bit crazy, it's actually the methodology, it's the idea, it's the concept I've used in all these other cases. And when I say we've got big legal teams on a lot of these class actions, so there's lots of lawyers, lots of barristers. But from Palm Island, I then worked on the stolen wages case in Queensland, and coincidentally, Pearson, who was the lead applicant, and anyone who's got connections up at Hopevale would know the Pearson family. But Hans had spent time on Palm, and his daughter's house was raided on the Palm Island in the Mullenjaiwakka case. So, it's sort of the connections there. But with Hans and that case, we sort of got to a point where the rest of the team were like, "Oh, what do we do with this racial discrimination component?" Because basically the racial discrimination case was white people didn't get treated like this, because they wanted to get into the federal court jurisdiction, because we all want to get in there because it's a bit more sensible. And so we got into and so I said, "Look, just leave it with me. I'll have a think about this part of the case." And I turned it into something really beautiful, actually. And it was about Queensland government, and during the course of the stolen wages reparations scheme, had signed up you couldn't get the $2,000 or $2,500 under the reparations scheme unless you signed a deed to indemnify the state. And so what I did is I said, well, that's discriminatory. And I said it's discriminatory because A, you're taking advantage of the fact that people have grown up in missions, they've got limited resources, lack of education, all those types of things, so $2,000 would be significant. B, you didn't provide them with any of the documents you held, because you've got all the documents to ascertain the amount of damage. C, they didn't have access to independent legal advice, pursuant to having those material. And so, because we're sitting in this mediation with the state, and it's funny, whenever you sit in these cases, everyone on the other side tells you how dumb you are and how smart they are. So anyway, we're in there, and I said to the funder on my side, I said, "Look, this is a really good case, and this is a part of the case that we can quantify. There's 7,000 people. We're talking about a low-end discrimination claims worth about $10,000. But as I said, they're not going to listen to us. We need to get Brett Walker." And so, and you need to bring in the big guns at the right time. It's a bit like bringing Chris and Brett is the big gun. And so we go down, and I hate working over Christmas, but I remember driving back. I think I was driving back from up north on New Year's Eve, or the New Year's Day, because I had to get back write this advice to send down to Brett for the next time we did this mediation. And anyway, I don't know what the other side's thinking was, but we walk into this mediation and then it's like, okay, well, give us a number. And it's like, okay, well, you know, if Joshua Creamer said something, fine, but we intentionally wrote this advice. We provided to the other side, assuming that the minister would read it. Assuming that the minister's only getting advice from her legal team who says we've got a crap case. Now, I don't know if that had any bearing on the outcome, but it is an important thing to be able to do. And ultimately that case, you know, we were able to resolve it. I think it settled for like $190 million or something. But you know, you've got to understand there's a sense of real injustice on these cases. Because the money, the labour that people put in to build cattle industries, to build railways, the money that they should have been paid in Queensland, the law said you must be paid, here's the amount under the award, but your employer will pay that money directly to government. And that's what happened. It's a real true stolen wages case. People worked, they never got the benefit of the labour. The money actually went to build infrastructure, built hospitals like Redcliffe, it built Aikenvale in Townsville, and you know all these other things that I think even the powerhouse was built on stolen wages money. So all that money was built, relied on black labour and black money. But the injustice being that people really, even in those class actions, they never get the true benefit of their loss. And Hans Pearson is a great example, and it will always sort of sting me in a way that all Hans ever wanted to do was to buy his own house. He started the stolen wages case because when he finished working under the Act, he went down to the police station where the protector was, and he wanted to access his account. His wife had kept his wage book. She thought they'd get about £2,500 and he'd buy a house up in Townsville. He went down and he had £50 in his bank. And this is where stolen wages starts. And years later, he walks into John Bottom's office in Cairns. John, you know, let's do something with stolen wages, and it sits there for a few years, and then we turn it into a case. But even at the end of that case, Hans still, with the little amount he received, there's no way he could buy a house. Now, having sort of worked on those, I then got the opportunity, obviously, we sort of rolled over to the Northern Territory and WA. And they were really in stolen wages and then stolen gen. And I just want to I'll probably talk about stolen wages first, but unless you worked across the country on the different jurisdictions, people don't really understand the nuances, the differences. Now, in the Territory, there was just no money cycling through the system. People were not getting paid. There was no requirement that they get paid an award wage. There was no trust held. What happened in the Territory, and I'm generalising here because I'm just talking about history in a very brief point, but they built the stations around the labour. So they built the stations around the mob because they wanted to keep the workforce on the stations. And the real obsession with government in the Territory was the removal of children of mixed descent. In Queensland, people's day-to-day lives was strictly controlled by the government. And that's easy to see in the thousands and millions of pages of records. But in the Territory, it was the pastoralists, the managers of pastoral stations and the station owners that exercised the day-to-day control over people. And government would come out and do their annual audits. And so they would identify who's there, their age, estimate their age and their living conditions. That was really people's limited interaction with government. Completely different to Queensland. And what we pleaded in all cases, but I thought it was particularly relevant for Northern Territory and Western Australia, was that it was in contravention of this Abolition of Slavery Act. I think it's an 1834 Act or something like that from the UK. because people were just truly working as slaves. Now, and you know, every blackfellow everywhere in Australia was being paid, you know, salt, sugar and tea and all those things, but that's all they were getting in the territory. And I remember on that case we went into the Stolen Generation Corporation in Darwin. There was a lady named Eileen Cummins. She was the chair of the corporation, and there was a few people sitting in there around probably a table this size. And we go in and we say to them, "Oh, we want to talk to you about stolen wages." And they're just beautiful people. They sit there and they listen to our presentation on stolen wages. And they're just waiting. We finish, and they say, "Okay, well, we want to talk to you about stolen gen." Okay, yeah, stolen gen. You know, Kruger, Cabillo, those cases have run. They've been unsuccessful. Like, we want you to help us. Like, Eileen's like, Eileen met with 6 prime ministers. She's still going, Eileen, too. But she'd met with 6 prime ministers since the Bringing Them Home report. There'd been this, you know, this advocacy around redress, and nothing ever had happened. And we, like, okay, well, and we said, a good mate of mine who's a class action lawyer, we said, all right, well, yeah, let's do it. Like, you know, we'll give anything a go. Don't worry about the cases that are lost, and don't worry about all those things. It's like, we'll give it a crack. And so we get this, you know, we get it together. We sort of polish up these cases, and we make them look like something. And we kicked that off, and we're going for about 12 months. And these are highly political cases too. So, you know, there's media engagement, there's political stuff that others are doing behind the scenes. It's all part of the strategy. And so we get to, and then and obviously that case ends. And that case ends when Scott Morrison gets up on the TV and says, "I'm going to announce a redress scheme for $380 million for the stolen gen in the Northern Territory and ACT." And then ultimately we negotiate another $50 million for family members, so it's like $430 million. And what really sticks with me about that case was, you know, when we sat down with Eileen and co, what troubled some of them most was the fact that their experience had continued to be denied in parts of the community and in the media. And I think I might have talked to Eileen the day or two around when that announcement came, but the validation of people's experience, the validation that this is what happened, is, you know, you're not going to get the people in the media saying, well, you know, unlike with all the Kruger and Cabillo cases, they could deny it happened and blah, blah. Well, when the Prime Minister gets up and announces apology and a reparation scheme, pretty hard to deny. And it's the same validation, I think, I got from when the WA case settled, and I had David Newry, if anyone's ever been up to Kununurra, and David called me that night. And because you realise when you're working on those cases, and particularly the Stolen Wages WA case, Stolen Wages WA, Mervyn Street, out of Fitzroy Crossing, or just out of Fitzroy Crossing. He was our lead applicant, but all Mervyn ever wanted to do was tell his father's story. He just wanted to tell about his father working for that black penny, putting that black penny in the tin and keeping it under his bed. And I think what I'm saying about that is there's so much of our history which hasn't been acknowledged. And there are so many in our community that carry that burden of not having that history acknowledged. And whilst those cases will never compensate people for really, truly what was lost, what we wanted to do in running those historical class action was to bring some validation, to bring an end to the denials or to, you know, the lack of acknowledgement by government about what had happened in our history. And we wanted to do that while that generation was still alive. And, you know, working up in the Kimberley, I will always love the Kimberley. As a boy from Mount Isa, all the old cowboys up there remind me a bit of the Kimberleys. But that is, again, a place where that true slavery existed. And what's different about the Kimberleys is, we had that brutal impact in Queensland around 1850s. In the Kimberleys, the second wave of settlement was in the 1920s. So, you can talk to people who can tell you about their mother or grandmother being shot on the beach at on some of those missions. And those stories, and what I sort of took from the Kimberleys was what happened up there must have happened here, but it's not in living memory. And up there it still is in memory. I mean, everybody got chained up, everybody got whipped. And the real brutal stuff is actually still recorded. And the work of some of our anthropologists, so Tony Redmond and Fiona Skyring, the anthropologist, historian, bringing some of that experience to life. And some of the material, I won't go into, but some of the material would talk about how people were tortured in Mullabulla and missions like that in WA, which probably happened here, but it's not recorded, or not in the material that I've seen. But I sort of got through those cases, those historical cases, and the plan was to try and bring some recognition while those are still alive. We haven't done a Queensland Stolen Gen, and I don't know if I could. I remember actually Tony and I were in that Incarceration Nation documentary, and I remember I was up in Darwin and I was interviewing the Stolen Gen women that day. And when you interview a lot of Indigenous women from that period, there's a lot of sexual violence happened to them on missions and stations. And actually, it's one of the reasons I was really keen to get Malia Ben or Evelina Tarago to the bar, because I just couldn't continue interviewing Indigenous women. It's a brutal thing to do. And I was sitting in my bed. We had a pre-screening. I think Tony might have been in Sydney, but we had a pre-screening of this Incarceration Nation, and I'd just been interviewing these old women who are like 80, 90, telling me about the abuse they suffered as kids. And I'm sitting on my bed at the motel in the Hilton in Darwin, and we watched this Incarceration Nation. And I think the first 5 minutes, I just watched the first intense 5 minutes, and I just started crying. And I just had to put it down, because I just had this brutal day, these women telling me these horrible stories, and I get the intensity of Incarceration Nation, and I'm just like, I just can't. When you got trauma in the history, there's only so much trauma you can manage at one time, and my bucket was overflowing that day. But, that sort of responsibility to bring those stories to life and to bring recognition for that generation was in a way what really led me to the work on the inquiry. And we've got Ivan's here and Nia's here and David's here. We've got a few from the inquiry. I hope I haven't missed anyone. But I took on the role because I've always felt a responsibility to share those stories and to acknowledge that history. But I also understood the bridge that could be made by that history with more people in the community knowing about it. And that came because, I spent 8 years working on stolen wages. I spent weeks and weeks in the Territory in Kimberley and months, and I'd come back to Brisbane, and I've got a good friend here, David Williams, and we'd be talking to people out home and school kids parents of kids that go to school with my kids, and I'd talk about that history. And it was hard because you'd come home, so you go out to Tennant or you go out to Fitzroy or some of these places, and you see people living in the worst conditions possible. Like, you go to Tennant, you just go off the road 100 metres to some of those little communities, and, our witnesses are living in sheds the size of this table with no running water and no electricity, right? This is like 2020. And you come back home and you're like, what's reality? Is it my life growing up, is my life here in Brisbane with all the great things I've got, or is what happening, like those, I couldn't reconcile those two worlds could exist at the same time. And that's like, if you go and work out, and I say to my mates who want to go and change the world, well, have you been outside of wherever? Have you got out to the communities? You only actually understood what the conditions are for people? And so I would talk to people about my work. I talk to everyone, black fellas, white fellas, lawyers, you know, I do stuff with the uni, academics. We've got 5 to go, 2 minutes. And I could talk for 2 days. I'm a barrister, I'm paid to talk for a living. And people were always receptive. And so I knew that telling the truth could make a difference. It could make a difference for our own mob and having their stories validated, but it would also make a difference for those people who are hearing it for the first time. And if we wanted to look at where we were going first, we had to do the hard work in truth-telling. Now, we've got some unfinished business there, so maybe some of you guys in the room will pick up that mantle and run with it at one stage. But, you know, as young lawyers and through your careers, you're going to find these moments and you're going to have a different interaction with what's going on. And I would always wonder why, when I go out and interview all these people, or we have this preservation evidence, why I would feel it so much compared to my non-Indigenous colleagues. Because we feel like we've got that responsibility. And so all I've ever wanted to do was to be able to deliver on that responsibility. Now, where to next? I'm not sure. But when I look around the room and I see, you know, all the next generation of amazing lawyers and coming through, I have a real sense and pride of being able to follow on from people like Tony and Kevin and Kevin. But you'll find these moments in your career where you've got to make a choice. And for me, it's always been about sticking to my values. Because if I wasn't making a contribution, if I was selling myself short, I wouldn't be able to get out of bed every day. Now, I'm happy to finish up. So thank you for that. Thank you for the opportunity. I again want to acknowledge Mullenjaiwakka for his significant contribution, for his friendship and mentoring over the years. And I hope in some way I can play a small role like that to some of you. So thank you.